Good morning, everybody. We're going to go ahead and get started on this session as far as contracting for security, privacy, and some vendor management aspects as well to contracts. Since we're at this conference, we felt the need to come up with some sort of hacker names for ourselves. So I go by Ray Zipsa as far as this presentation goes, and this is Donkey Kong, but my real name, I don't know if I should say it. It's in the materials. So first, whenever you come to the legal presentation, it's always prefaced by this disclaimer: nothing we say here should be taken as legal advice. And then they proceed to give you legal advice, which is always kind of odd to me. So we don't have a disclaimer. This stuff, you can take it to the bank. Feel free to rely on this as much as you want. However, if you feel it creates an attorney-client relationship, we'll be happy to charge you for your time on the way out the door, cash only. All right. We're going to cover 10 topics through the time we have together, some in more detail than others. And this is a quick overview of what we are going to cover. One thing I want to caution, though, before we jump into the material is that there is sometimes a temptation when we cover it this way to look at these provisions and topics as silos within an agreement. And that's not really the best way to look at a contract. You really need to look at it holistically and recognize that sometimes if you're going to give up in one area, you can often make those provisions up somewhere else in the agreement. When you understand what you want to get or what you need to concede, look at other spots in the contract where you can get those things if you're going to have to give it up in a certain section. So even though for convenience purposes we're talking about these as discrete sections, recognize that that is not the best way to look at a contract, and instead you need to look at it holistically. So without further ado, I will hand it over to my colleague Donkey Kong to talk about often where the conversation starts when you're dealing with a vendor.
So the first thing that you're going to notice when you're dealing with a vendor is there will be an initial fight over whose contract you're going to use. Larger, more sophisticated enterprise users of, particularly, we're going to touch mostly on software as a service agreements in this presentation. So large enterprise users of software as a service oftentimes will have their own internal contract that they use, and the vendor will oftentimes respond and say, well, this is the document that we use, and this is the agreement that we're going to use going forward. The reason that the vendor will give you as to why you have to use their agreement is that they require all customers to use a particular form, or that it might simplify the process. And oftentimes it will come with the guarantee that the terms are very fair and that all their customers agree to this. In fact, this is lifted from something that we received, and this is what we consider in some ways kind of the standard line from vendors, which is all of our customers operate under the same MSA, which reflects standard software as a service industry terms in use by thousands of companies. And make your legal group aware that this is a thumbs up or thumbs down agreement, and they should not waste time doing a markup. So a couple things to point out here. First of all, Nate and I work, predominantly in information technology agreements, have been doing this for a significant amount of time, and I can tell you I don't know of a single standard set of industry terms in use by thousands of companies. That simply just isn't true. And when I receive an email like this from the legal side and it says this is a thumbs up or thumbs down transaction, this email alone makes me think that this is a thumbs down transaction.
And I think it's important to point out that when they say this is not an enterprise software licensing, then what does that even mean? It's not like enterprise software licensing and SaaS are two opposites of each other. It's not like there's one or the other. So when we got this email, we called up the client and we're like, what is this thing? I mean, maybe it's not that significant. And they're like, oh, no. It's a $750,000 agreement, so feel free to review. But you see the starting point that the vendor provided us at the outset.
So obviously, if you agree at the outset, and we're going to look at a lot of these provisions typically from the customer side. If you agree at the outset that you're going to use the vendor paper without any sort of fight, I mean, obviously that's an automatic loss of positioning right off the start. The legal review, to the extent you send that document to your attorneys, is going to cost more to review. I mean, if they can start with your standard agreement and just review red lines to that, as opposed to starting fresh from a vendor agreement that they've never seen before, it's going to be less expensive to review the first. Additionally, it's more to manage, because if you're not dealing with one standardized, from the customer side, if you're not dealing with one standardized agreement that is yours, and you're dealing with different terms for each different vendor, it can put a stress on your vendor management team. One compromise that we have used, and some software as a service providers will agree to this compromise, is you give them the opportunity right off the bat to incorporate their most important provisions into your standard agreement. Don't present it the way that oftentimes the vendor will present it to you, which is this is an up or down. You have no choice but to agree to our terms. Allow them to make some changes, because a lot of times some of the changes that they make will be just fine. Additionally, you can, what we would call is pump things to an order form. So if there are fights in terms of whose contract to use, if there are sticky situations, and you think, you know what, sometimes we might really want to fight for this particular provision and other times not, you can simply send it to whatever the order document is going to be and address it at a later time. In a lot of ways, that's simply kicking the can down the road, but it can help you to get an agreement in place. And then when you're actually talking about ordering the service and giving the vendor $750,000 as an example, oftentimes then they're a little bit more willing to bend on how important that term really is.
I didn't say this at the outset, but we are attorneys. And we do focus, Ken and I both, 100% of our practice on technology and software licensing, all the issues related to that. So we have seen a lot of these agreements, and as we work through this presentation, we've pulled provisions out of contracts that we've seen, that you've probably seen as well, and use those as bad examples, and then some compromise language potentially down the road. And if you want a copy of this presentation, we're more than happy to give you a copy. Just give us your business card and we'll email it to you. So if you want to use these provisions, use like the second ones, not the first ones, because the first one's very vendor friendly, assuming that you are a customer. If you're a vendor, then I guess use the first ones. Now, the issue here is, as we've moved to the cloud, the idea generally is that these contracts are going to be simpler. There's going to be less burden on your IT department, and accompanying that notion is this idea of not only are the contracts easier, but all you have to do is click the I agree and we're good. It's a cloud agreement. There's no real negotiation, to Ken's earlier point. That's not really true. At a minimum, you should print out the click-through agreement and put a signature block on it and sign it and file it away somewhere, so that if there's any sort of dispute down the line as far as what the terms of the agreement are, you can go back to a document and say, look, we agreed to this. If you're clicking an I agree or I accept sort of provision and not keeping a copy of it, then you're going to be in a tough spot when you need to interpret terms later. Yeah? That is a great question, and sit tight for about 5 minutes because we're going to cover that specifically. But that is one of the concerns, is the modification of terms down the road. The other issue is that these click-through terms are often very one-sided, that they have been drafted with the vendor's concerns in mind, and they are not going to be very favorable. The notice and change provision is additional concern that we'll flesh out a little bit more, but what you don't want to do is undo with a click-through something that you've already negotiated in the past. So sometimes you'll negotiate this contract, the vendor will send an update of maintenance or support or something that will require a click-through that then can negate all of that prior work that you've done. So you want to be very wary of click-through agreements, and despite what they say, if there's enough money on the table, these things are negotiable. So don't fall into that trap of thinking you can't negotiate it.
All right, so next we're going to consider modifications, and really there's two types of modifications we're thinking about here. The first is modifications to the terms. So to your point, you just asked the question a moment ago. And then the second one would be modifications actually to the service that the vendor is providing. In terms of, we do understand most service provider agreements, when they first are sent to you, will say, you know, we can modify these terms upon notice to you or upon posting, you know, notice of the change on the website. If you simply click through and don't, actually get a signed copy and negotiate at least that provision of the agreement, then you are subject to the vendor saying, 2 years from now, well, actually, we changed the terms. And I don't know if you noticed, but we did post it on the website, and you agreed that we could do that. So that does become an effective mechanism for amending the terms of the agreement, unless you negotiate it at the outset and get it out of there. So from our position, especially if you're talking about that this agreement has now made its way to the attorneys and you're looking for a legal review of a document, I mean, this is a no-brainer. You can't allow a provision in there that says, yeah, we're going to spend money on negotiating the terms of this agreement with our service provider, and then after we sign it, we all agree that you guys can change it whenever you want. So this is language that would specifically address that point in the agreement. It simply says, you can't amend this agreement unless we all agree to it in writing. The other thing you can do if you're dealing with a particularly sticky vendor and they really don't want to give on this provision and they're not negotiating with you, it's a fairly small, deal, and you guys don't necessarily have the negotiating power that you would like, you can provide that the agreement can be changed with them providing you a certain amount of advance written notice. And what we would say in that situation is then you need to give yourself a termination right if you disagree with any of the changes that are made to the agreement. That's a last kind of, worst case scenario. But that at least is a minimum. You need to have some right to get out of the agreement and not continue to be bound by changes that you haven't agreed to. In terms of changes to the service, there's a back and forth in terms of what the vendor might see as, look, we need to be able to improve this service over time. We need to be able to make changes to it. We need to be able to potentially discontinue services that, a significant portion of our customers aren't using. You're not counting on certain functionality at the outset, but you want us to be able to improve the service over time. On the flip side, if you're the customer, how you might see it is, look, it might be beneficial for you to add some functionality, but most often the terms that the vendor agrees not only allows them to add functionality, it also allows them to take it away, and oftentimes allows them to stop providing the service altogether. Now, if you have, work within an organization, if you've gone to leadership and you say, this is the solution that we're going to use moving forward, and then 6 months from now you have to say, that functionality that we all thought was very imperative to that service, well, they don't provide it anymore. And by the way, the contract gave them the right to do it. So to compromise in this particular situation, when you're dealing with modifications to the actual service, most often we would use something we would call like a one-way door or similar to that concept, which is to say, service provider, that's fine. You can make changes to the service. You can increase the level of functionality. You can make the services better. You can make the service more secure. But you cannot remove any of the functionality that we're currently using throughout the term of the agreement. We've paid you a set amount of money, oftentimes in advance, to use this service for a specific amount of time. You can't reduce the functionality that we're receiving. And most service providers, I would say, would agree to this provision.
All right, SLAs. I love this one. I just love getting in the weeds on SLAs. So this is a provision, this is actually a little bit better than you might see at the outset in a contract. Oftentimes the initial cut says something like, we will provide the service, or we will use reasonable efforts to provide the service to you, full stop. So this is one step better, but not much. And the thing that I like about this provision is that it looks good when you're reading it, but when you get into the details of it, it may not be so good. So you start reading this thing and you're like, wow, 100% uptime. That's fantastic. Like, they're willing to put this in the agreement. Well, you got to keep reading because it also excludes then what is scheduled or emergency maintenance. Well, all right, hold up. Scheduled might be okay. We can talk about that, but emergency maintenance, that doesn't seem right. And then it keeps going. So downtime exists when you're unable to transmit or receive. Okay. And is measured from the time the trouble ticket is opened by the customer. So it gets really philosophical, like if there's a downtime and nobody's there to see it, does it actually count as downtime? Apparently not for them, but maybe it should. So then we got to keep on going though. Upon receiving a report, then you will get a credit for 2% of the monthly fee up to 50% for the affected service. Well, and that applies to each hour of downtime. So what has started out as a 100% uptime commitment within the first 7 or 8 words of the provision, nothing really happens until there's been at least an hour of downtime. So now you're down to 99.85. So you got to go there, and then you're only getting 2% of the monthly fee, capped at 50%. So if it's down for the entire month, you're still only getting half of the fees you paid, despite getting none of the service you paid for. So these are the kind of things that you need to flesh out. And a couple of the things to look at, first of all, if it's not clear, beware of the standard language from the outset from the vendor. And if you need to measure multiple things, feel free to get a little bit more specific as far as the SLA goes. So are uptimes the only thing that you are concerned about, or do you need to be worried about response times too for messages sending or being received, sometimes measured in milliseconds or whatever. And then get that uptime commitment on paper. Most vendors will know what their uptime has been over the past 6 months, past year, past 5 years. And they should be willing to commit to that if it's somebody you want to work with. I always would be wary of somebody who says, oh yeah, our uptime's been 99.99 for the last year. Well, let's put it in the agreement. Well, we can't agree to that. Well, why not? It provokes an interesting question. And then you got to figure out what counts as downtime. So on the previous provision, as it talked about scheduled or emergency maintenance, well, let's figure out what scheduled means. If you call us up in the morning and say, oh, by the way, the system's going to be down this afternoon, scheduled. All right, that's not what we're getting at in this provision. So how much notice do you need for it to count as scheduled? Do you need a couple hours? Do you need a couple days? Do you need a couple weeks? SLAs are very flexible in the sense that you're not going to need the same SLA for every contract that you're working on. You can probably get away with some lower levels for non-critical type of software, but those things that are running the enterprise and you need access during the day, like if it's an online store, for example, and it's down, you're not making any money, well, you're going to want high level of commitment. And flesh out what is scheduled. Sometimes if you can't get the notice, maybe you just have a standing maintenance window during which downtime won't count against the commitment. Figure out who's going to, so you also maybe want to include a cap on the amount of downtime that you can have in a month. So you can do it during these hours, but no more than 4 hours in the entire month or whatever. Figure out who's going to monitor uptime. I had a client who said, you know what, we always want to monitor it because it turns out when the vendor monitors it, they never fall lower than their uptime commitment. It's crazy how that works. So we want the ability to do that too. Some vendors will push back on this and say, look, we don't want your monitoring of the system to actually affect the uptime of the system. So we need to figure out how you're going to do that in a way that's not going to affect the actual delivery of the service itself. And we get you guys in the room with their guys, and then everybody figures it out at some point. You want to address what the remedies are too. So we talked about that credit in that previous provision and the ability to recover for a certain percentage for a certain amount of downtime. You saw that cap in there though, that 50% cap. That doesn't make any sense just as a fairness argument, because again, what if it is down for the entire month, or what if it's down for more than, 50% of the month? We are going to be losing money at that point. You also want to consider maybe having a trigger in there for excessive downtime in any one month or continual failures to hit the uptime commitment that aren't really bad but annoying. So if you have this system that is, it's supposed to be, let's say 99.9, and 1 month is at 99.8, 1 month is at 99.85, 1 month is at 99.7. Oftentimes these credits will be your sole and exclusive remedy, and we'll talk about that in a minute, but oftentimes they'll be your sole and exclusive remedy for failure to hit the uptime. And it's not enough to make you want to walk away, but it's certainly aggravating. So you want to have maybe in there, if you don't hit the uptime in 3 months, then we can terminate. And maybe you're not going to terminate, but at least it provides that stick to the vendor to have some motivation to address any issues that arise because they know you could walk away. The other thing I like to do when we're working through the SLAs is just pull out my calculator and say, all right, let's figure this out. Let's assume we have 1 hour of downtime this month in the middle of the day that affects our operations. And then run through the formula that they've provided to you and figure out if that makes any sort of business sense to agree to. Oftentimes, spoiler alert, it doesn't. You go through this and you figure out, oh, okay, if it's down for a couple hours, we're going to get $75 back. Then you think, all right, if I have to go to my boss and say, well, all right, it was down for a couple days here. Good news is we get $75. Is that going to get you fired or not? So I would do that analysis and provide that to the vendor and say, look, I cannot with a straight face go to my bosses and say, hey, we were down on Black Friday. Good news, $150 back for us. Again, is that going to get you fired or not? And use that. It's oftentimes the calculation is laughably small for uptime commitments. You're never going to get rich off of your uptime commitment because you're only going to get money back that you've paid or are supposed to pay. But again, it provides that stick for the vendor to respond to concerns that you have. So here's a couple provisions, sample provisions that deal with a few of these aspects, not all of them. And again, SLAs have so many moving parts and variables in them that you can often get what you want if you're creative in how you look at them, as opposed to just focusing on one piece, the amount of credit or the percentage itself. So this first provision deals with scheduled downtime and the notice and the amount of downtime that you can have in any given month. The second paragraph deals with this situation of chronic downtime. So if it falls below 99.9 in 2 consecutive months or 3 months in any 12-month period, or if you have 1 month that is really bad, if it's below 90% in this example, then that allows you the right to terminate. Like I said, it just gives them a little bit added motivation to help you out when the system is down.
Just one thing to briefly cover about SLAs and a lot of these terms of the agreement. So if you look back at the SLA that we're showing here in the language, in reality, you might be sending any of your agreements to a lawyer to look at, you might not. But in reality, the SLA is really a business term. So this is really about allocating risk and determining what your acceptable risk levels are for downtime. And so in the end, your attorney can try to negotiate, the language that they want in the agreement. But the reason that it's vital for you guys to have an understanding of the SLA is because in reality, it's really a business risk that you face in the end, which is our system went down. How does the contract deal with that? How does the contract allocate, what the uptime needs to be and how we figure that out? So the attorneys can negotiate the terms of those SLAs for you, but in reality, in the end, it's a business decision in terms of what you're willing to take on risk-wise. So termination and suspension, we're going to cover this very quickly. Most often, service provider agreements will have this large kind of very overbroad statement that we can suspend or terminate your right to access or use any of the service immediately without notice if we think in our sole discretion that any of these things have happened. So for example, that your use of the service could adversely impact the service offering of the systems and content, or that you're in breach of the agreement. This is a very problematic provision, and oftentimes if you talk to the salesperson about why it's in there, they will like to gloss over the language and say, well, we really don't terminate agreements for this provision, but we just need to reserve the right to suspend your access. That isn't what the provision says, but that's how it will be sold to you. In terms of, when you're talking about privacy and security risks specifically, if you're looking at a termination or suspension and you've given the vendor the right to terminate the agreement or to perpetually suspend your access to the service, what does the agreement say about continued access to your data? What does it say about what the service provider is going to do with the data now that you're terminated? You can no longer access the service. I mean, what's going to happen? Does it just sit out there? If you have paid attention to the security and the privacy, risks and how that's allocated in the agreement, but then you say, hey, you guys can terminate our access to this at any time, and no one paid attention to what happens to the data in that situation, that's a significant concern. Additionally, what are the service providers, continuing obligations? So if they do elect to utilize a clause like this and you haven't negotiated it out, do they have any ongoing obligation to give you your data back despite the fact that they terminated the agreement? These are things that should be addressed if you're going to allow a provision like that in. And then finally, these are some things that we would recommend if you see a provision like that to talk through with the vendor. The first is there should be a logical separation between suspension and termination. And in fact, the termination portion of that language should not even appear in that provision. These are suspendable offenses. They should be limited to the amount of time it takes you to correct whatever it was that gave you the right, or that gave them the right to suspend you from accessing the service. But termination should be an entirely different provision that essentially says, if we materially breach the agreement, you can terminate access, and there's notice and cure for all of those sorts of things. Additionally, even if the vendor's only going to suspend access, you still are probably going to want notice of that. So we would fight for at least as much notice as they can give you, so that you have some advance notice of the fact that, hey, we're about to be locked out of our account, or we're about to, to no longer have access to this particular service for a particular set of time. We have some language here that addresses those points, takes out the termination right, and obviously provides for the advance notice. So this, once I said, this is something we'll cover quickly, but just bear in mind that if you're giving them the right to terminate the agreement for what might have just been a simple breach, it shouldn't be addressed here. It should be addressed elsewhere.
All right, so talking about disaster recovery and data backup responsibilities. This is language straight out of Amazon Web Services, so if you've had any agreements with them, this might look familiar if you read it. But notice what the obligations are in this. So you are responsible for configuring the service and taking your steps to maintain the security of the content, and you are solely responsible for taking appropriate steps to maintain security, protection, and backup of your data. So what does AWS have to do here? Nada. There's nothing they're supposed to do. All of the obligations are on you, which may be okay, but you want to understand what your risk is going in. So some things that you need to talk about. So backup, data backup. Are we giving data to this supplier who is going to have the only copy of it? Or are we going to maintain a backup of the copy, a backup of the data ourselves? If we are maintaining a backup, maybe we're okay with them not having any sort of backup responsibilities. But if they are, how often do they back up the data? If it's daily, is that okay? What about every couple hours? Maybe it's, again, system critical. We want that more frequent backup. And then where are those backups being stored? Now, I realize that most vendors are not going to relocate the geographic location of their backup facility for you if you are not happy with it. Having said that, at least you know what the risk is. And a lot of these provisions are in there to help you have that conversation with the vendor, to ask the question and know, okay, it's too close, or they're both within the same city or whatever, or it's in Florida and they're going to get hit by a hurricane. We may want to be a little bit extra cautious around this time of the year. Again, you want to have that conversation and just be aware of what those issues are. So what about disaster recovery? And I want to separate two issues. Are they providing you disaster recovery services for a disaster that you have versus their own disaster recovery services for the data that they are housing that you have? So keep those in mind as far as what you're talking about as far as disaster recovery goes. But you want to see if their plan is sufficient. Well, how are we going to know if their plan is sufficient? You got to ask and you got to look at it. Again, most vendors are not going to modify the terms of their disaster recovery policies, their internal policies, for you. But again, you want to look at them and at least have a copy of it so you can say, all right, we understand how things are going to work here. Then you can analyze whether it's adequate or not. Who can declare a disaster? If they are providing you disaster recovery services, is it on you to declare the disaster, or do you have to rely on them to declare the disaster for you? So the compromise areas here are really to make sure that you're all on the same page and to make sure that any of those obligations are memorialized in the contract. You're not going to have a whole section of their disaster recovery policy. It's often attached as an exhibit to keep things a little bit more organized in the agreement, but you have those provisions and those obligations in the agreement, and make sure that they satisfy whatever your requirements are. I do want to make one other note as far as disaster recovery goes, though. Often in an agreement, you'll see these force majeure clauses or acts of God, which say neither party is responsible for things outside of their reasonable control, including, and then it's a list of terribles, right? War, strikes, zombie apocalypse, sinkholes, whatever. Like all that stuff is listed out that everybody's not responsible for if it happens. Think, though, that if they are responsible for disaster recovery, either for themselves or for you, those disaster recovery obligations should be carved out of the force majeure provisions, because that's the entire point of disaster recovery. Those things are disasters. And so you don't want them to say, we don't have to provide disaster recovery services because a disaster happened. That doesn't make any sense. So you want to make sure that if there is a force majeure and there is disaster recovery services, that those two provisions don't conflict and they each account for each other.
All right, so now we're going to get to the heart of the security portion of the contract and to what you're going to look for from a vendor when you're discussing the contractual security obligations. A quick primer on this is that especially for large organizations, but really for all organizations, there should be some sort of due diligence system that's put in place, and it's in advance of getting to the point where you're taking the agreement to the attorney and saying, can you look at this agreement and tell us, what it looks like? Because you might want to know, these questions about disaster recovery and about whether or not they can satisfy the minimum security requirements that your organization has. No one likes to have paid an attorney a significant amount of money to have reviewed an agreement and find out, 2 days before you're getting ready to sign this thing that, oh wait, we just got the disaster recovery plan and it doesn't meet our organizational requirements, and the whole thing's off. Now you've paid a lot of people a lot of money to do things, and it's all been for naught. So there should be some due diligence on the security obligations of the vendor in advance of getting to the point where you're negotiating the terms of the agreement. You should ask for, and the vendor should be willing to provide, at least some evidence of their track record with security. This is often done through some sort of security questionnaire that really is the IS and security teams that send these to the vendors and get some of that minimal information all the way up to some of the most detailed information about what the vendor can do and has done for security. And then additionally, once again, this is kind of a help us, help you note, understand in advance of sending. If you're talking about, software as a service, before you send the agreement to the attorney, you should be able to explain to the attorney, what data is this vendor going to have? What data could they potentially have access to? What would happen if there was some sort of a security breach with this particular vendor? I mean, those are things that your attorney should turn around and ask you if you're not providing them up front, because it has a significant outcome in terms of the sorts of security obligations that we're going to look for in the agreement and ask the other side to sign on to. So oftentimes in an agreement, you'll see, most software as a service vendors are advanced enough at this point that they have at least a minimal security provision in their agreement. Oftentimes it'll look like this. We're going to operate in conformance with our operating security and privacy policies, and we're going to act promptly to address any nonconformance therewith. And then we're going to give you annually our SSAE 16 or successor type audit report. A couple of concerns about this. First of all, what are their operating security and privacy policies? They're not even referenced in this section, through a hyperlink, which oftentimes they will. Here, you have no idea. If you just go with the terms of this agreement, you don't know what those security, operating, and privacy policies are. Additionally, yeah, they might act promptly to address any nonconformance therewith, but if it's caused you some harm, do you get any, are you made whole for the harm that was caused because they failed to live up to their security policies? Or do they just say, well, hey, moving forward, we'll fix that? Additionally, it only covers an SSAE 16 or successor type audit report, and that might not be sufficient depending on the type of data that you're providing to the vendor. So some issues to consider when you're looking at security obligations in the contract. This is a duplicate, but the type of data that you're going to be giving to the vendor is a primary concern. Legal requirements that are on you for securing that data. So if it's payment card information, if it's information that has been transferred to your company from the EU, personal data about EU residents, if it's protected health information, if it's particularly sensitive personal information. I mean, all of these things are things you need to take into account, because if you have legal obligations on you to protect that information with a certain level of security, and the vendor doesn't, you're ultimately the one that's going to be held responsible for that. Additionally then, some common areas of disagreements when we're looking at the security obligations from vendors. A big one, who takes financial responsibility if there's a breach of security? I mean, that is a significant issue, and in the end, it's a business issue, but there are, significant fights, and this is one of the last issues, generally speaking, to get settled with any of these agreements before they get signed off on. What level of attack triggers notice? I mean, what level of security incident would require the vendor to say, hey, by the way, we had, a security incident that you should be made aware of?
So to Ken's point just previously made about who pays in the event of a breach, if you are not in a situation where the vendor or the service provider has unlimited liability, so that's always the best, is that if there's any breach that you're responsible for, service provider, you pay for everything associated with that breach. Any sort of legal costs that arise, notification, staffing a call center, credit monitoring if it's appropriate, notice to the media, all of that, you pay for it. That's always the best situation to be in. If you have to agree to a cap, understand there are some things you can do on your end that can both increase and decrease the cost of that breach per record, which is ultimately in your favor, because if there's any costs from that breach that exceed the cap, those are going to be on you. So here are some factors that actually increase the cost of a breach, and these are based on per record numbers. So the going rate for a breach in the United States right now is about $250 per record. So just figure out in your mind, okay, number of records, and that's like number of individuals involved, times 250, that's how much a breach is going to cost us. There's some things, though, that increase the cost of that breach. So if the device is lost or stolen, it increases it by $9. If there's a third party involved, that'd be like, well, not you guys, but hackers. Not you kind, though. I hope. But here's what's interesting. Notice that quick notification increases the cost per record of a breach by almost $9 per record, which is a fairly significant increase. And you think, okay, as Ken mentioned, all of these statutory and regulatory and industry regimes have, and states even, there's 47 states that have notification requirements, have some time frame built into that notification. You need to notify within X number of days, ranging from potentially 5 days in California for certain types of breaches to maybe you get 60 days at the other end of the spectrum, but it's somewhere usually in that range. So when a breach happens, everyone immediately starts freaking out and thinking, all right, we need to get these notifications out as quickly as possible because we don't want to run afoul of any of these other requirements that are imposed on us by statute. But if you get a notice out too fast, it's actually going to cost you more because maybe you notify the wrong people or not enough people. Maybe you have to provide a supplemental notice before you have all of the information required. All of these things, when you start acting too fast, actually increase the cost per record of the breach. So this speaks to the second part of this, which what can actually decrease the cost per record of a breach. And you'll notice the trend for most of these is some sort of enterprise-wide understanding and awareness of data security and a plan to deal with it. So if there's a CISO or somebody else who has enterprise-wide responsibility, decreases. If you have some business continuity management, again, decreases. If you have a plan, it decreases the cost. So think about this. Incident response plan decreases the cost per record by $12, but it also prevents premature notification. So you're actually saving that $9 too. So you start to see how some of these things build on each other. Again, encryption. My clients ask me, do we need to encrypt this stuff? And I say, well, you don't need to legally, but you probably should. And encryption covers a multitude of sins. It's so great if it's applicable, if it's feasible within your business environment and financially doable, even if it's a bit of a stretch, it can save you from so many problems down the road if that data is compromised. Another thing that was interesting for this that's not on here, but employee training saves you about $8 per record, and having insurance like cyber liability insurance saves you about $4.50 per record, which may seem a little counterintuitive because you think, well, we have cyber insurance, we can just be careless with these records because insurance will cover us if there's any issue down the road. To the contrary, it actually, cyber liability insurance is more of an indicator of an organization that takes security seriously. So that the presence of cyber liability insurance speaks to this organizational-wide awareness of data security and response if there's any sort of breach.
All right, so we're going to cover then some security obligations that are what we call must-haves in an agreement. And this is how to use this slide, at least from my perspective. If you think, you know what, I'm going to take what these guys just told me, we're going to go out and we're going to look at some agreements and we're going to try to maybe negotiate some of these on our own, which I would not advise you to do. But if you think that's, you know, we're going to plan to just take a look at these, or if you're taking that initial look at some of what the vendor is agreeing to from a security obligation perspective, and they tell you no to any of these particular issues, these should cause, you know, this should be a cause for serious concern. These are red flag issues that if the vendor, it might not be in the initial agreement, but trust me, the vendor covers it somewhere on one of their websites or something. If they're not willing to sign up to these obligations, there is reason for concern. First of all, and this is standard language, most states or even the federal security laws that are in place, and when I say security, I don't mean, you know, like the SEC security, I mean like, you know, data security laws that are in place, that the vendor is going to implement reasonable and appropriate administrative, physical, and technical safeguards to protect your data from a whole host of things. This is very spongy language, which is why vendors tend to agree to it, but it is required language because you are going to want to make sure that they're meeting at least that basic requirement. You can get into a fight later about what was reasonable and what wasn't, but that's certainly something that you're going to want to have in the agreement. Additionally, ensure compliance with any applicable legal or regulatory industry requirements. So the concern here is, you know, maybe you want to go to the attorneys and figure out what these are. But if you know, for example, that you work for a healthcare organization and you know that there's protected health information, you know, red flags should be going off if this organization isn't willing to sign a business associate agreement and, you know, acknowledge that they might have access to protected health information. Consider that the agreement needs to address EU personal data if that data is going to be transferred to a service provider. It needs to be covered. There should be a discussion about the transfer mechanism that's in place to get that data out of the EU. Third-party audit requirements. They're having them done. They should sign up to, you know, they should put that in the contract. They will be done on an annual basis. And moreover, they should also agree within the contract to actually implement any changes that are recommended as a result of those audits. Notice of security incidents. Obviously, once again, that's a no-brainer. They need to provide you notice if they have some sort of security breach. And then also, if you are dealing with, like, you know, where you've allowed them to put terms located somewhere, you know, on a website, then you need to cover it with a provision that won't allow them to just materially change or reduce that level of security they're providing unless they give you notice and an opportunity to terminate. Because once again, if they come to you and say, you know what, remember when you first signed up to use the service, we said we were PCI compliant. Well, we changed our whole security system, and we don't really deal in payment card information anymore, so we're no longer PCI compliant. But you can't continue to use that vendor for, storing, payment card information. It just can't be done under PCI in order to maintain your compliance. So you need to have the right to terminate the agreement if they fail to live up to these obligations. Yep. If you have specific, I would say the big ones, Graham-Leach-Bliley, HIPAA, PCI compliance, EU personal data, those should be specified right in the agreement. Otherwise, the first provision actually covers most of the obligations that you're going to have in most state data security laws. So to the extent that you deal in an industry that has known specific standards, I keep going back to PCI, but that's because it's a really easy example, and it's something that I think a fair amount of businesses probably overlook. If you're dealing in payment card information, there are obligations on you to have a contract with your service provider where they acknowledge certain things. So when I say, applicable legal or regulatory requirements, it's those sorts of requirements I'm talking about that are specific to an industry. Well, oftentimes the vendor will, in documentation that they have hidden on some website that you might not, have been given access to or might not know of off the outset. But in terms of compliance with legal requirements, that's on the customer. If you're sending them data and they have to have, minimum security procedures in place, so knowledge of the specific legal standards is going to be on the customer because it's the data that was provided to you. So, you're kind of the responsible party for that data. And so when I include in here the legal requirements, that probably is one that you're going to want to, ask an attorney about, and that you're going to want to consult with, in-house counsel or whoever you have working on these agreements for you, because the obligation to comply with those legal requirements is going to be on you, and that's why you need to pass those along to the service provider through the agreement. Yep. Some things that we'd like to have in agreements, but these are compromise spots, and you might not always get all of these things. Some of them, frankly, are probably a bit of an overreach, but a vendor obligation to provide you with a network diagram that outlines their IT network infrastructure. You might ask for that from a vendor, and a lot of vendors might say, absolutely not. But you should have really what we're driving.
Hi folks, Alan Geek here. Another Ever Media freeze up, so we don't have any audio until about the 45-minute mark. Sorry for the problem.
come in and protect you from those claims. So it's generally limited to those third-party situations. This is a very specific indemnification that you might see at the first cut, and it's actually not bad as far as it goes. It deals, though, specifically with intellectual property only and only in the United States. So if this is a situation where there are no professional services, no on-site services, and not outside of the United States, this is probably not bad, but one thing it doesn't deal with at all is data security and breaches. So that's one thing you want to think about is, okay, if we have a security breach of some sort and our data gets out, are you going to come in and indemnify us? So we get sued by a customer or a state attorney general, you come in and you protect us from that claim in addition to paying for any expenses that we would have as a part of that. The other issue is if you're providing services to us that are not timely, what kind of protection do we need or what kind of remedies do we need if the failure to provide those services incurs some liability on our end. So here's some compromise language that gets at some of these things. You can see the indemnification itself is much broader, but it also applies to our use of the services. And then notice this bottom one. This is specifically to address situations where there might be on-site services. The typical example I use is vendor comes on site, kicks over a gas can in your data center and burns the place down. Well, they should be on the hook for that sort of thing, which under the terms of the contract, they may not be, because it links in to this second issue, which is limitations on liability and any caps on damages that I referenced earlier. So you can see what they say here. They're not liable to us or anyone else for loss of, and then a list of things, including data. All right, well, let's talk about that one, vendor. We're giving you data, or you're creating or processing data for us we don't have a copy of. You should be on the hook for any sort of losses that arise. And then look at this last sentence in the first paragraph where it says, nothing in these terms will limit or exclude our liability, so vendor's liability, for gross negligence, intentional misconduct, or death or personal injury. They legally can't limit their liability for that anyway, so they're not giving you something here with this sentence that you don't otherwise already have. So them saying, oh, look, we're uncapped for gross negligence and death, well, thanks, I guess, but you didn't even have to say that, and we still have it. And then you see the second paragraph, which is the cap on liability. $100. Again, if you walk into your boss's office and be like, all right, well, they burned down the data center. Good news is we got $100 out of them for that. So what you might often hear, though, from a vendor is this second bullet down here. They might say, look, if we uncap our liability for you or for all of our customers, then all that's going to happen is if we have a problem, somebody's going to get a lot and a lot of people are going to get nothing. So instead, says the vendor, how about this? How about we cap our liability for all of our customers, let's say $10,000, so that if we go down, at least all of our customers get $10,000. I say, well, I'm not representing all your other customers, and I don't believe for a second that I'm the biggest customer that you have and that you haven't agreed to uncap liability or a higher cap for another customer. So that provision, capping liability for all their customers, only works if they've done it for every single one of their customers. If they've uncapped it for one of them, then you're out of luck. So I never believe for a second that that's going to hold any water. And we can limit it to certain provisions. We say, look, we don't need it unlimited in all situations, but let's reach a compromise here. Let's duke it out and figure out where we can agree. So for specific claims that implicate a high amount of damage that we cannot mitigate ourselves, so IP infringement claims, we have no idea whether you stole this from somebody or not, whether you developed it in-house. We have no way of knowing. There's nothing we can do to mitigate our damages. You should be uncapped for that. Or a data breach. If our data is compromised by something you do and it gets out there and there's thousands and thousands of records out there and we get sued by individuals, there's notification costs, again, vendor, you should be responsible for that. If it's just a vanilla breach of contract claim, okay, we can agree to limit or cap our liability in those situations, but these other areas where we have no control, where we are relying entirely on you, you should not be able to cap those damages. Again, though, this often goes to who has the leverage in the conversation. And if it's a small contract, you're just not going to be able to get the higher caps that you want. If you have to agree to a cap, you may look at some multiplier as opposed to just fees paid, so maybe a 3 times or 5 times multiplier. See if they have insurance. See if you have insurance that will cover this, and start looking at other ways where you can mitigate your damages in the event of some of these significant breaches of the agreement that will result in a lot of cost to you. If they have insurance, maybe you say, okay, we can agree to a cap to the amount of insurance that you carry, or something like that. So with that, we're happy to answer any questions you might have, or we'll stick around. Yeah, those are our real names and emails. Go ahead. Yeah. Yep. Yeah, so yep, I will. It was more of a statement, more of a battle cry than a question. As far as cyber liability and the state of the industry right now, a lot of cyber liability policies that you may get for yourself are more whole than cheese in many ways, that there's more exclusions to them than actual protection that you're getting under the cyber liability policy. So you really need to be careful when you're looking at those and when you're buying them. The industry is starting to mature. The insurance industry is starting to mature a little bit. I will say that one advantage to cyber liability policy beyond just the dollar amount that you have is your insurance company will often have some breach response plan built in. In fact, when you experience a breach, I tell clients your first phone call should be to your insurance company, and then your second phone call should be to me, because oftentimes your insurance company will have attorneys that they want you to work with, forensic investigators that they want you to work with, and they can get you going on the right path. All right. We'll stick around, though. If you got other questions, we're happy to answer them. Thank you.